Hello, this is Richard Ollie and welcome to Topic 2. This is the first mini lecture in Topic 2 and we'll take an overview of the Australian Constitution. Now, if you're a Singapore student, you really don't have to know this. However, you might find it interesting because it will allow you to compare and contrast the Constitution in Singapore with the Constitution in Australia. There is another mini lecture that will follow this, which looks at the Constitution of Singapore, and the Australian students may well find that interesting for the same reason, to be able to compare and contrast both countries that have come out of British law. So the Australian Constitution is the source of all federal law. And in fact, in its own sense, it's also the source of state law, because it says within it what is in the remit of the federal government and what is in the remit of the state government. The Constitution sets out the powers of both the state and federal government. And prior to Federation in 1901, Australia consisted of 6 separate colonies, all under British rule. But on the 1st of January 1901, the Commonwealth of Australia was created, which in turn created the Commonwealth Government and the Federal Parliament. And it divided power between the Commonwealth, or the Federal Government, and the states. This idea of separating powers comes from the work of Montesquieu, a very early scholar and philosopher. And the doctrine of separation of powers comes from those who felt that civil liberties were at risk if key organs of the government are controlled by one person or one group. So it led to the germination of thought about separating the various powers of government so they are not controlled by one person or one group. The Constitution defines how power is divided between the Commonwealth and the states to make laws. And Section 51 of that Constitution lists the express powers of the Commonwealth that will override any state laws if there is any inconsistency found between the state laws and the federal laws. Section 109 of the Constitution provides that the Commonwealth laws will override the state laws if they're inconsistent. And any power not expressly stated in Section 51 are considered residual, sometimes referred to as reserved, powers of the states. So basically, Section 51, and we'll talk more about this later, contains 39 express powers of the Commonwealth. And if the Commonwealth can't make a law that can be put against one of those 39 powers in Section 51, known as placeta, then they can't make a law on it, because it is the reserve power of the states. So the Commonwealth has 39 express powers, and the states have everything else. When we look at the Constitution, the chapters themselves tell the story. Chapter 1 talks about the Parliament, Chapter 2 about executive government, Chapter 3 the judicature. So the first 3 chapters really are about how separation of power is achieved within Australia. The Constitution then goes on to talk about finance and trade, both international and between the states. Chapter 5 talks about the states and territories. Chapter 6 is a small area looking at how a new state might be formed. Chapter 7 is a grab bag of things called miscellaneous, just for machinery of government and to make the Constitution actually work. And Chapter 8 is a specific chapter that says the Constitution cannot be altered unless this very specific process is put into place. And we'll talk about that later in this lecture. When the founding fathers, and they were fathers at that time because they were all men, first drafted the Australian Constitution, they did so by building in a system of structures known as checks and balances that were purposely designed to ensure good government. These checks and balances were designed to prevent government power being concentrated in the hands of a small number of people who may at some time abuse such power. This comes from the writings of Montesquieu that we discussed in a previous slide. It's true to say that those who drafted the Australian Constitution held a similar view that when power is concentrated in the hands of a small number of people who are not accountable, this is when the greatest threat to human rights emerges. In many Commonwealth jurisdictions, the phrase peace, order and good government is an expression used in law to express the legitimate objects of the legislative powers conferred by a statute. The phrase appears in many Acts of Parliament, most notably the Constitutions of Canada, the Commonwealth of Australia, and New Zealand, and South Africa. If you contrast these words with the words life, liberty, and pursuit of happiness, which is a spiritually similar phrase found in the United States Declaration of Independence. So the structure that's required by the Constitution is designed to prevent power from being concentrated. So our 5 protections that are absolutely within the Australian Constitution is that it sets up for a bicameral parliament, meaning it has an upper and a lower house. The upper house in Australia being the Senate, the lower house being the House of Representatives. And before a law can be made, can be gazetted, both houses of Parliament have to approve that law unamended. The second is the separation of powers, and we've discussed that briefly, and we'll talk about it more later in this lecture. The system of representative government, in that senators and members of Parliament in the House of Representatives are elected from people within prescribed electoral districts within Australia, and therefore they represent those people. A system of responsible government, meaning that the Parliament is responsible to the people who elect them, and the fact that none of this, in fact nothing in the Constitution, can be changed except by having a referendum specifically to change the Constitution, and that has a prescribed process as detailed in Chapter 8 of the Constitution. So let's look at those protections to start with. First of all, a bicameral parliament. This is one that has 2 chambers, a lower house, and you can see on your screen the lower house at a federal level in Australia is the House of Representatives, which is themed green, and an upper house, or the House of Review, which reviews mostly legislation that starts down here in the upper house, but legislation can be introduced via the Senate, but mostly it comes from down here in the lower house. And the Senate reviews that legislation, and if it agrees with that without amendment, sends it back to be voted on in the Parliament. And when we do the topic on how laws are made, you'll see how that actually operates. At a state level, all state, formerly known as colonial parliaments, also had 2 chambers. And when the Australian colonies gained self-government in the late 1850s, Western Australia was in the 1890, the upper house was called the Legislative Council, and all states except Queensland now remain bicameral with an upper and a lower house. Queensland abolished its upper house in 1922, and several attempts were made to abolish the New South Wales Legislative Council, or their upper house, until it became a directly elected chamber in 1978. Legislative councils, or upper houses, have been reformed so that they have the same franchise as lower houses, and all except Tasmanian Legislative Council are elected by systems of proportional representation. Since 1909, just out of interest, Tasmania has used a system of modified preferential voting in single-member districts with staggered 6-year terms, and one or more members retiring at annual periodic elections. Upper houses are an important component of the lawmaking process and Parliament's ability to scrutinise the actions of government. Now let's talk a little bit about the doctrine of the separation of the powers. The doctrine of separation of powers in Australia divides the institutions of government into 3 branches: the legislative branch, the executive, and the judicial branch. The legislature makes the laws, the executive puts the laws into operation, and the judiciary interprets the laws. The doctrine of separation of powers is often assumed to be one of the cornerstones of fair government. A strict separation of powers, however, is not always evident in Australia. Instead, the Australian version of separation of powers tries to combine the basic democratic concepts embedded in the Westminster system of government, which is the system of government in the United Kingdom. It also tries to embody the doctrine of responsible government, meaning the government is responsible to the people. But it also tries to bring in the United States version of separation of powers. And the issue of separation of powers in Australia has been a bit contentious over the years, and one that continues to raise questions about where power lies in the Australian political system. Although it's assumed that all branches under the separation of powers do not overlap, there is sometimes a common ground between all 3 levels. In Australia, there is little separation between the executive and legislative branches. And we see this coming into focus in an older case referred to on the course site, Victorian Stevedoring and General Contracting Co. and Meeks and Dignan, where the High Court held that a strict division between these 2 levels was not practical and reaffirmed the Constitution to outline this. So, as we said before, the first 3 chapters of the Australian Constitution are headed respectively the Parliament, the Executive Government and the Judicature. Each of these chapters begins with a section by which the relevant power of the Commonwealth is vested in the appropriate persons or body. The historical context in which the Constitution was drafted suggests that these arrangements were intended to be connected with federalist ideas along American lines. If we look at the Judicature, the first thing we need to look at is the role of the High Court. The High Court is the highest court in Australia. It was established in 1901 pursuant to Section 71 of the Constitution. The functions of the High Court are to interpret and apply the law of Australia, to decide cases of special federal significance, including challenges to the constitutional validity of laws, and to hear appeals by special leave. It's not automatic, you've got to get leave of the High Court for them to hear the appeal. So appeal by special leave from federal, state and territory courts. The seat of the High Court is in Canberra, where it's located in its own building within the Parliamentary Triangle. The High Court building houses 3 courtrooms, justices' chambers or offices, the court's main registry, its library and corporate services functions. In addition, there are offices of the High Court Registry in Sydney and Melbourne, staffed by officers of the High Court. In Adelaide, Brisbane, Darwin and Perth, the registry functions are performed on behalf of the High Court by officers of the Federal Court, and in Hobart, they're performed by officers of the Supreme Court of Tasmania on behalf of the Federal Government or the High Court of Australia. Representative government needs further explanation. Representative government is a form of government founded on the principles of elected individuals representing the people as opposed to autocracy and direct democracy. Representative government is based on representative democracy, which is a form of democracy in which citizens allow others to represent them in government processes and are not necessarily directly involved in any of the processes of legislation or lawmaking. In representative democracies, the representatives typically serve in the chamber such as the Senate or the House of Representatives. And in the state parliaments, they're known by slightly different names. This might seem as though it creates unnecessary separation between the people and the laws that are being made, but the intention is that the representatives receive the education and training that are necessary to better understand the complicated needs of their jurisdiction. The fourth principle, or protection, that's embedded in the Constitution is a system of responsible government. Now, this is a conception of government that embodies the principles of parliamentary accountability, which is the foundation of the Westminster system of parliamentary democracy. Governments and the equivalent of the executive branch in Westminster democracies are responsible to the Parliament. Responsible government of parliamentary accountability manifests itself in several ways. Ministers account to the Parliament for their decisions and for the performance of their departments. This requirement to make announcements and to answer questions in Parliament means that ministers have to be members of either House of Parliament. Secondly, and most importantly, although ministers are officially appointed by the head of state and can theoretically be dismissed at leisure, they retain office subject to their holding the confidence of the lower house of Parliament. Once the lower house has passed a motion of no confidence in the government must immediately resign or submit itself to the electorate in a new general election. This is the meaning of it being responsible, ultimately, to the people. To remain in government, a party or a coalition of parties must maintain the support of the majority of members of the House of Representatives. This is part of the principle of responsible government. It ensures that the government is accountable to the Parliament. In Australia, the principle of responsible government works together with the principle of separation of powers to guide the way in which laws are made and managed. And the fifth protection is constitutional change only by referendum. A referendum is a vote of the Australian people on measures proposed or passed by the Australian Parliament. There are a number of different types of referendums that can be held. The most common is a constitutional referendum. Any proposed change to the Australian Constitution must be put to a vote of all Australian voters in a referendum. The Australian Constitution can be changed by referendum according to the rules set out in section 128 of the Constitution. A proposed change must first be approved as a bill by the federal government. It is then sent to the Governor-General in order for a writ to be issued so a referendum can occur. A referendum is a national ballot on a specific question to change the Australian Constitution. In a referendum, the Parliament asks each Australian on the electoral roll to vote. If a majority of people in a majority of states and a majority of people across the nation as a whole vote yes, called a double majority, then the proposal to amend the Constitution is agreed to. Otherwise, the Constitution remains unchanged. In 1906, when the first referendum was held, Australia has had 19 referendums in which 44 separate questions to change the Constitution had been put to the people. Interestingly, out of those 44 separate questions, only 8 changes have been agreed to. Successful referendums have included the 1946 referendum, which allowed the Commonwealth to provide social service benefits to returned servicemen and women. The 1967 referendum, in which 90.77% of people voted yes, gave the power to the Commonwealth to make laws for Indigenous Australians. In 1977, a referendum which gave the people of the territories the right to vote in referendums changed the way casual Senate vacancies were filled and forced federal judges to retire at 70 years of age. Unsuccessful referendums have included a 1951 referendum which asked to make laws about communism and communists. In 1999, a referendum which asked whether Australia should become a republic. And how the Constitution is interpreted has also changed and evolved, even without a referendum. These changes have occurred under our existing Constitution and have been brought about by High Court of Australia decisions. In terms of constitutional rights, there are 5 explicit individual rights that are contained within the Constitution. The first of these is the right to vote, contained in section 41 of the Constitution. The second is the protection against acquisition of property on unjust terms. That's in section 51, Placet 31. The right to trial by jury, which is section 80. Freedom of religion, section 116. And the prohibition of discrimination on the basis of state of residency, which is section 117. However, there are some implied rights within the Australian Constitution. The first of these is freedom of speech. And in recent years, the High Court has found that additional rights for individuals may be necessarily implied by the language and structure of the Constitution. In 1992, the High Court of Australia decided that Australia's form of parliamentary democracy, dictated by the Constitution, necessarily requires a degree of freedom for individuals to discuss and debate political issues, which is the very issue that was determined by the High Court in the case of Australian Capital Television Proprietary Limited and the Commonwealth, which is a 1992 case. This famous case, and others to follow, provided us with the High Court decision that found that there is an implied freedom of speech in our Constitution in regard to governmental and political affairs, and the decision was based on the very nature of representative democracy and representative government. The second is freedom of assembly and association. The right to peaceful assembly protects the rights of individuals and groups to meet and to engage in peaceful protest. The right to freedom of association protects the rights to form and join associations to pursue common goals. The right to peaceful assembly protects the rights of individuals and groups to meet for a common purpose, or in order to exchange ideas and information, to express their views publicly, and to hold a peaceful protest. The right extends to all gatherings for peaceful purposes, regarding the degree of public support, regardless of the degree of public support, and for the purpose of the gathering. However, the right applies only to peaceful assemblies, not to those involving violence. Whilst the High Court's jurisprudence on the implied freedom of political communication has been well developed in the past 20 years, there's been much less focus on the question of an implied freedom of political association, or freedom to associate more generally. Cases that concerned association rights have been decided on other grounds. The rights to freedom of association protects the rights of all persons to a group together voluntarily for a common goal and to form an association. Examples are political parties, professional or sporting clubs, non-government organisations and trade unions. And the third implied right is the right or the freedom of movement. The right to freedom of movement includes the right to move freely within Australia for those who are lawfully within the country, the right to leave any country and the right to enter a country of which you are a citizen. The right may be restricted in certain circumstances, and the right to freedom of movement within a country includes the right to choose where to live within the country. People must be able to move freely and choose a place of residence within a country without restrictions, including establishing a purpose or reason for doing so. Governments have a duty to ensure that the person's freedom of movement is not unduly restricted by others, including private persons or companies. The right applies to all persons lawfully within the Australian territories, not only to Australian citizens. The Australian legal system is based on fundamental beliefs in the rule of law, justice and the independence of the judiciary. All people, Australians and non-Australians alike, are treated equally before the law, and safeguards exist to ensure that people are not treated arbitrarily or unfairly by governments or officials. Principles such as procedural fairness, judicial precedent, and the separation of powers are fundamental to Australia's legal system. The common law system as developed in the United Kingdom forms the basis of Australian jurisprudence. It is a distinct form of civil law system that operates in Europe, South America and Japan, which are derived from Roman law. Other countries that employ variations on the common law systems are the United States, Canada, New Zealand, Malaysia, India and Singapore. The chief feature of the common law system is that judges' decisions in pending cases are informed by the decisions of previously settled cases. This is known as precedent. The Australian Constitution of 1901 establishes a federal system of government under which powers are distributed between the federal governments and the states. It defines exclusive powers, investing the federal government with the exclusive power to make laws on matters such as trade and commerce, taxation, defence, external affairs, immigration and citizenship, and concurrent powers where both tiers of government are able to enact laws. The states and territories have independent legislative power in all matters not specifically assigned to the federal government by virtue of Section 51 of the Constitution. Where there is any inconsistency between federal or state laws, then federal laws will prevail. Federal laws apply to the whole of Australia. In effect, Australia has 9 legal systems: the 8 state and territory systems and 1 federal system. However, it is the state and territory criminal laws that mainly affect the day-to-day lives of most Australians. Each of the federal and state systems incorporates 3 separate branches of government: legislative, executive and judicial. Parliaments make the laws, the executive government administers the laws, and the judiciary independently interprets and applies them. Constitutional law is a body of law which defines the role, powers and structure of different entities within the state, namely the executive, the parliament or the legislature and judiciary, as well as the basic rights of citizens. And in federalist countries such as Australia and Singapore, the United States and Canada, the relationship between the central government and the state, provincial and territory governments is very important. Not all nation states have codified constitutions. All states have a jus commune, or law of the land, that may consist of a variety of imperative and consensual rules. These may include customary law, conventions, statutory law, judge-made law, or international rules and norms. Constitutional law deals with the fundamental principles by which the government exercises its authority. In some cases, these principles grant specific powers to government, such as the power to tax and to spend for the welfare of the population. Other times, constitutional principles act to place limits on what governments can do, such as prohibiting the arrest of an individual without sufficient cause. The Constitution is a document that is about preservation of rights and limitations of government power. It is the source of all laws in the country that has it as its constitution. Thanks for your attention.